This is a topic that was specifically requested by you guys of, hey, I would really like this to be something that we cover in greater detail. So specifically talking about the high-risk refusals, the aid to decision-making capacity, and the emergency custody order process. This is a complicated topic, and this becomes complicated because of the fact that there are legal aspects to this, there are ethical and moral aspects to this. There's also just the psychology of the fact that these are sometimes frustrating because we're not set up for success, that we're able to just go do the thing that we think we want to go do. So we're going to talk through a bunch of different aspects. There are some parts of this that we're going to be talking specifically about the Commonwealth of Virginia law, and it's going to feel like, wow, we're blazing through this. And that's because you guys aren't cops. You're not going to be enforcing the law. So the intent here is for you to have an awareness of it and then know what tools you have to be able to successfully navigate these different incidents. So how often and who in here gets super excited when you hear the EMS 40 whatever, you've been dispatched for the high-risk refusal? Is there anybody in here who's like, I love that call? It's not really that enjoyable of an incident. It's frustrating on a lot of different reasons. We all, even if you aren't the one that's getting called to the scene, we've all had the difficult refusals. Why is it frustrating?
Because you want to do what's right.
Yeah.
And you're trying to do the right thing, and somebody just kind of like, yeah, no, I'm not doing that.
Yeah. So we have in our mind what we think is the right answer, and then sometimes you find yourself asking, like, well, why did you call me then? If you didn't want what I was going to offer you, why did you bring me into your home, tell me a lot of stuff about you? Or why did somebody else bring me into this situation if you didn't want to be a part of this? So there's a legitimate component to this that we're not able to self-actualize. We're not able to do the thing that we expected to do, and that becomes a little bit frustrating. There's also the confusion aspect of it of, I'm not 100% certain what the right answer is here. So sometimes it gets a little bit difficult and frustrating because I'm not sure what the right answer is. I would like to do this, but I don't know if in 2 years I'm going to be sitting in a courtroom having to talk about what decision I made here. So there's a lot of different things that make this frustrating. There are some concepts from medical and legal ethics that we probably need to talk about so that everybody is on the same page and has an understanding about them. So the first one is the term paternalism. Has anybody in here heard of the term medical paternalism? What do we mean by that? What's that?
Paternal meaning father.
Yeah, so it's like, well, what does your father do for kids usually? Yeah, dad knows best. Dad's going to have an idea about how we're going to deal with the situation. We're going to tell the kid, hey, this is what we're going to do. So apply that to medicine. How would, if you were on the scene of an incident, how would you potentially act like a dad?
Towards the patient? Are you talking about the patient? So you want to do what's best for the patient, right? You want to try to convince them, like, be stern, but understand what they're going through, understand like the issues, right? But you want to be stern.
Yeah. So you want to do what is best for the patient from your medical subject matter expert perspective. And it's pre-hospital EMS, honestly, we don't deal with this a huge amount. We want to take folks to the hospital because that's usually what the right answer is. We want to give them care because that's usually what the right answer. This often applies to what John talked about earlier. Hey, you are dying. You need a transfusion. You need blood products. And I am a physician. I am licensed to provide this care, and I know you need it, so you're going to get it. Well, what if that patient's values don't match with yours? What if that patient has a religious reason of why they don't want that thing? Are they wrong to say that, hey, that's not what I want? But medical paternalism refers to that, the dictator, and one of you may remember the correct term while I come up here and look at my notes, the benevolent dictator, who I'm trying to do the right thing, I'm trying to make sure that I take care of you, but I'm doing something that you may or may not actually want. So that comes into play when it butts up against patient autonomy. So everybody in here has heard the term autonomy recently because we talk about fully autonomous robots, we talk about AI, all these different things. What do I mean when I say patient autonomy?
They're used to doing a certain way, like, no, I usually don't. Right, you get called for a lift assist. Right, I just need help getting off the floor. I don't need to go to the hospital, this is what they do for me when you guys come.
So they have an idea of what they want their care to include.
Right.
So if you're making an autonomous decision, who ultimately is making the decision? If you have autonomy, yeah, you are. It's my ability of self-determination to say, this is what I want from my care. So we hear the term thrown around all the time, shared decision making in medicine. That's where you have the patient involved to the level that they're able to be involved to make the decision for themselves. And sometimes that's like negotiating with a toddler of like, I'm not gonna ask, do you wanna put clothes on? It's okay, do you wanna wear the red shirt or the blue shirt? But we're providing them with information. But ultimately, as long as the patient maintains their decision making capacity, they should be allowed to make decisions that match their own values. So how do we know if somebody has decision-making capacity? What is decision-making capacity, Heather?
If they're alert-oriented and they understand the context of the decisions that they are making.
Okay, so alert and oriented. So they're able to process information. They have an understanding of what's going on. And then you said the second part was understanding the context. So they're able to essentially understand the environment around them, understand their medical condition, understand the information that we're providing to them. They need to be able to understand. They need to be able to appreciate the situation, and that sometimes means understanding and appreciating the consequences that are associated with things. So you can know that today is Wednesday, but if you aren't able to fully understand that, hey, I think that you're having a heart attack. The metrics that I can use to test whether you're having a heart attack is telling me that you're having a heart attack. And the potential consequences with not going to the hospital and receiving care is that this heart attack could get worse and you could die. Can you repeat that back to me? And if they don't understand and can't put into their own words that same thing, they can't appreciate the potential consequences with that. And that requires that they have the ability to reason and to communicate with you that they understand that. And that gets exceptionally difficult if you have somebody who has a communication barrier at baseline. What patients, what folks do we interact with regularly that have communication difficulty? Dementia. What else? Stroke. People with a second language. Sometimes we think about things from a language barrier or a communication difficulty as a physiologic thing. It may just be that I haven't taken the tools that are available to me through the language line or whatever else to make this communication happen. What else?
Intoxication.
Intoxication, which then they're going to have other things that are going on that's not just isolated to communication strictly. What about autism spectrum disorder? Someone who may be able to process information, but they communicate in a completely different way than we do. So these are always challenges to make sure that we understand what is their baseline level of communication and how do they communicate effectively. And all of those complicate and they lead to us being exceptionally frustrated. Now, one thing that's important to understand about decision-making capacity is that it is situation specific. What do I mean by that? Are you always in the best headspace to make decisions?
You're just overloaded. Yeah.
Yeah. It could be that somebody who is normally able to make great decisions for themselves is either oversaturated with information or physiologically has something going on. They're not perfusing their noodle, whatever the other reasons are. Suddenly they're not able to make decisions effectively for themselves by virtue of their medical condition. It also changes over the spectrum of a lifetime. You wouldn't ask a 2-year-old to make a complex medical or legal decision, but then once that 2-year-old is 20 and theoretically has gained the ability to reason, to communicate, to weigh the different consequences of their decisions, suddenly that changes over time. You cannot confuse decision-making capacity with the legal term of competence. And if anybody's gone through an internship in the last decade, you have heard the medical directors explicitly talk about this. Competence is a legal term that is determined by a judge, whether that person has the ability to make medical and legal decisions for themselves. None of us, including our physician partners, have the ability to determine competence. But decision-making capacity is likely weighed in that decision of whether somebody is able to be competent to stand trial, to make decisions for themselves, or whether they need a designated person to make decisions. So we balance the decision-making capacity, we balance the patient's autonomy, and we balance our desire to avoid being paternalistic with wanting to avoid medical negligence. Now, you heard me mention earlier in the week, actually last week, where do we carry the greatest likelihood of being found negligent in our career path in emergency services? What do we do on every call that we're very open for liability? What's that? Accidents. Motor vehicle accidents is specifically the place that we run into. Medical negligence in the emergency services world it's a much higher bar to have to jump to. But obviously making sure that we're not making grossly negligent decisions that may set us up for failure is extremely important. So there's 4 Ds of medical negligence. The first one is that they have to prove that you had a duty to respond, which if you're standing here in a uniform getting paid to respond to calls, it's pretty easy to make that connection with your duty to respond. There has to be a dereliction of that duty. Either you didn't show up or you openly and clearly didn't do the right thing. There has to be a direct causation that your failure to uphold your duty actually caused damages to that individual. That's a bunch of leaps, and unless anybody in here is moonlighting going to law school, most of us don't need to worry about trying to prove these or remember these. But the easy, simple answer is, in the back of your mind, am I doing the right thing? Would I be able to justify what it is that I'm doing? And is it worth me picking up the phone and calling somebody else and saying, hey, do you mind checking my work? Would you be comfortable with your name being on this as well? That's the way that I avoid grossly negligently acting in my capacity. Loop in somebody else to assist you. And it is a balancing act. It's important for us to respect the patient and their wishes, while also making sure that we are not forgetting to notify them of information, to take all of the steps that are required to arrive at a point where we have made sure that they're okay to make a decision not to go to the hospital, or if we need to loop in other folks to help us with getting somebody to go to the hospital when it is not what they desire to do. So, part of the reason I bring this up is, does anybody in here actually know what is on our EMS informed consent to refuse? Every shift you have somebody sit down and sign that thing, but how many of us have actually read it and understand it?
I've read it.
What's that?
I said I don't have it memorized, but I've read it.
Yeah, most of us, whether it be because you ask folks to actually read it or somebody in your EMT school told you, hey, you should read this thing, or you may actually, if you're old enough to remember paper forms, it was easier to read on the paper form, so we just continue to have it easy to go through that way. But we're going to talk through what's on the EMS informed consent to refuse form so that we all know what it is we're actually asking folks to sign. So, they're saying that I am of age to make this decision. And you can reference the EMS manual. Age of consent in the Commonwealth is 14. We talk about the nuances of when there is a decision maker that is there for them versus if they're dealing with an emancipated minor versus if they're dealing with somebody who is under their care as far as a mom. All of those things are spelled out specifically, but it's pretty simple of, is this person able to make decisions for themselves?
What age did you say?
Age of consent is 14, Commonwealth of Virginia.
Consent to what? Like, decision maker is 18. There's a 14 to 18 ambiguity that is only under certain unique circumstances you can make a very narrow subset of decisions.
Yes. So 18, easy. 14, take a look at the documentation that's there to figure out, do we fall into one of these specific circumstances?
Decision making for the care of their child or decision making around the care during pregnancy, I believe.
Yes.
Reproductive health, that's children, emancipated minor, or substance use disorder type.
That's it. Otherwise, stick to the 18.
They don't, it has to be, there's not in there is the consent to a refusal. Because that's also like not an emergent consent. You've got time to solve that, so it winds up being excluded.
Yes. So it gets confusing into that gray area between 14 and 18.
Yeah.
What's that?
I'm saying, talk after you go. This guy's keeping everything.
Yeah. You're of sound mind, not under the impairment of any alcohol or substances, legal or illegal. You understand that we are not physicians. In some cases, there may actually be a physician that's on scene, but we more are focused on the fact that We don't have the tools that are necessary in a hospital to be able to affect the full assessment of these folks. You understand that there's things that the hospital can offer that we cannot offer, and sometimes it's important to make sure that they understand that. So, like, hey, this is what might happen if we go to the hospital. There might be blood work. There might be x-rays. There might be additional tests that they're able to do there that we can't do. Because a lot of times when folks pick up the phone and call 911, they think that we are doing everything that they would do at the hospital, and it's important to educate them on what that would potentially look like. You understand that we always recommend evaluation at a hospital. You understand that there is the potential that you have an injury or an illness that is serious, and that there are potential complications or consequences with this, up to and including disability or even death. That is all directly from the thing that you ask people to sign every single day. You also understand that you can call 911 again, and I reiterate to folks that could be in 2 minutes, that could be in 2 hours, that could be in 2 days. And you accept full responsibility for you or the person that you're signing for's medical condition, and that you release the liability to Fairfax County Fire and Rescue Department. Now, how effective are waivers of liability in court of law? They're generally useful for like simple negligence. I'm not going to hang my hat on the fact that just because they signed something saying that I'm not responsible, that I'm suddenly not going to be responsible. It's the same as when you go through any amusement park. They've got the thing that says we're not responsible for this, but if they yeet you off of a roller coaster, you're probably going to have somebody sue on your behalf and make some money. So even though that's in there, the majority of what they're signing is an acknowledgement of information that we have passed to them. Obviously, none of that is effective if they can't understand that information. All right? So there's different levels of risks associated with a refusal. Is there such a thing as a no-risk refusal? Is there such a thing as a low-risk refusal, honestly? I mean, maybe. How do we make our high-risk and medium-risk refusals into low-risk refusals?
Cover yourself.
Like with a blanket? You can't see me!
I mean, just make sure you go through all the appropriate steps.
Okay.
And go to the appropriate channel, like phone a friend.
Yeah.
Call the hospital, make sure it's recorded on that line, so if they go back, they can hear the patient, you know, saying that they don't want to go, and they understand. They heard everything explained, and they made the decision.
Yeah. So involving other people in the decision, being thorough with not only what you discuss with the patient and what you assess, but also how you document that. I like all of those things.
I ask them to read it back too. If I really,
Yeah.
really think they should go and they're really don't want to,
Yeah.
I'm like, okay, what did I just say? You know, I want you to read back to me that you.
Yeah, so there's reading it back off of the form, which shows cognition, versus, hey, tell me in your words how I just explained that to you.
What did I just say?
That takes it through a whole different level of now not only were they listening, but they understood, can comprehend, synthesize, and then reproduce that information back to you. That's phenomenal. That's kind of the gold standard. Especially then if you have a witness who's uninvolved, witness the fact that, hey, all of this was done, they're making this decision because they understand.
Yeah, that's my go-to as well.
Yeah, how about a situation where a third party calls, I tried to talk to my mom and blah, blah, blah. Maybe she just woke up from sleep but she was not herself. And then we get there, but we see that she's fine, everything is okay. She's like, I'm okay.
Yeah.
I don't know what's going on, but I'm fine. So I think that would be a low risk situation for us.
That's a pretty low risk situation. How can we help to mitigate that risk further so that Beth doesn't get a call at the fire chief's office? What's that?
We also want to communicate with the daughter.
Yeah, close the loop. I mean, we'll be honest here. So Randy Krantz taught my medical legal class when I was in college, and he's the Commonwealth's attorney down in Danville, and he's a former flight medic, former flight nurse, phenomenal guy, and he used to always say, people don't sue people they like. So if you take the moments to try to communicate with folks to make sure that they understand, especially if they're the one who called 911, we kind of owe them a little bit of like, hey, here's the general synopsis of what was going on within the confines of what we could talk about from a HIPAA perspective, but close the loop with them. If they cared enough to call us, we should care enough to let them know like, hey, here's what happened, here's what we're doing with this. Are you good with that plan? And if not, how do we educate you to make sure that you understand what's going on with the plan? What else? How else do you guys mitigate risk? How quickly should a refusal be processed?
I don't think there's a time limit. It's situational dependent.
It is. If you're on scene for 2 minutes and you somehow come out with a refusal, were we able to do anything in that time? No.
You already discoed that based on your dispatch.
Yeah, you walked in with the expectation of not.
Things that we could do in the emergency department, you're talking about x-rays and CTs and labs. One of the benefits is serial observation. There's a benefit to some benign neglect in the ER, is the time that it takes me to do anything is long. And I know that you have survived the hour, 2 hours, whatever, that it took me to get you through the sausage making conveyor belt.
Yes.
That's what used to drive me crazy, with people saying the medicated can continue in to get the refusal.
Right.
They've just been there to get all
You
that
have a relationship
good-
with that
They
provider.
have that good information and all they want you to do is come in and get the.
That shouldn't be a thing anymore.
That's not, it
I'll come in and
definitely-
handle the iPad.
It slowed down when the iPads went.
Yeah,
like,
oh, he's
everywhere.
Where's your iPad, brother?
A lot, but having-
Anything?
Yeah, right.
Yeah.
Something also,
Yeah, I'm sorry.
when you have an elderly patient, everybody's used to talking over them,
Mhm.
the provider. But if you sit down and you talk with that patient, it empowers them, and a lot of times you can win them over to take them to the hospital.
Yes.
You talked about downshifting your gear on the notification of death.
Mm-hmm.
I find that is critically important too, and it's something that if I'm like not mindful of, I can lose sight of. Because I'm not waiting for them to give an answer. I'm like giving their answer for them, anticipating what the answer's gonna be.
Yeah.
And I have to remind myself,
So taking the time makes a big difference in doing a thorough assessment, presenting your information and your findings, allowing them to process that information, and then come to a decision when they maintain that decision-making capacity that we can not alleviate all risk, but really put ourselves in a position where we've done the right things and then we document it effectively.
I think one of those places we often think we're at low risk, and it could be lower risk, is like those calls, like those diabetics or those, those overdoses. And oftentimes those patients will do fine with refusals, but we're so quick to go into that call like, oh, this is a low blood sugar, we'll fix it, we'll be out of here. And we just immediately like almost push them to the refusal, like even if you don't say it, and you're like, okay, you investigate a little more. Oh, this is the third time that your blood sugar's dropped in the past 2 days.
what, you're not on insulin, you're not on oral
Oh,
agents?
Yeah.
Yeah, that's not insulin,
What
this
was
is your.
filled yesterday?
And so we miss the critical things that should make this a transport, and we're just like, oh, diabetic low blood sugar, this is a quick treatment, and refuse, and we
And
put
it's
ourselves at
natural
risk.
because our brain looks for patterns of best fit. And most times it is fine. And if we stop at that and don't look for, is this an exact fit or is it look like it but not really? We can
Yeah.
skip over that. Yeah.
Absolutely.
And sometimes the approach of not giving it, I mean, I don't want to say paternalism. I mean, I do go in sometimes, I'm like, okay, let's go. Like, the crew's already been there for 45 minutes. Like, they've exhausted everything. So maybe you act like, well, you can't get, I'm not going to give you a choice. Sometimes it works. Gently.
Yeah. And there's
Okay, let's go.
there's
The
different.
one that you clearly know should go.
Oh, yeah.
There's flavors of it.
Like the
That's
old
why
lady that's been on the ground for 6
Imagine
hours.
you're seeing in your head the one that I actually think they should go.
What do you say?
Like,
we
she
get on
has no
stretch?
choice but to go. She can't actually physically get
And
off
yeah, it's
the
like
ground.
reducing shoulder dislocation.
Yeah.
You don't do it
And her
quickly.
husband's like,
You don't try to overpower it.
Yeah.
You fatigue the muscles and the shoulder pops back in. So the same thing, you're kind of overcoming it. Sometimes the yellow print instead of white print is all it takes. Sometimes you just put on a white coat, or you say you're talking to the doctor and I say it. I almost want to give you a white coat to have in the medic unit or the engine, and you just put it on and see, I said.
I just called the doctor. They said you cannot stay here.
Yeah.
Let's go.
Yeah, and there's
Get the magistrate on the line, you're like, okay, fine, I'm going.
there's flavors of consent as well. Like if you, all right, let's go ahead and get onto the stretcher, and they've been saying I don't want to go to the hospital, but now they get up and get on the stretcher. Okay, I'm not forcing you. There's flavors of that, but so what happens when we move over towards the high risk? What makes a potential refusal high risk?
The consequences of you leaving.
Okay.
What's gonna happen to that patient?
What do you mean by consequences?
Like,
Dude's gonna die.
yeah.
Okay, so I've got a patient who I legitimately am concerned that there is a medical emergency at play, and if I leave, I don't know what's going to happen to them. Okay?
You're at a 3rd-degree heart block.
Yeah.
I really think you should be seen at the hospital.
Yeah.
The paper cut, granted, that's hard to make. You could die conversation.
Yeah.
Be logical. Hard for that to come out of your mouth. When the disease entity that you're entertaining is more sinister, it's more intuitive. Sometimes when the patient's fragile as well, you know, you've got malignancy with metastasis, liver failure, heart failure, kidney failure. You have no phone, no friends, no doctor, no insurance, no car. Well, if this goes wrong, it's going to go horribly wrong.
Yeah. What else?
Sorry, go ahead.
They fail the get up and go test.
Okay, that's a wonderful one.
If you can't get up and independently take care of yourself without us here to assist you, nope, you're not staying.
Yeah, if you can't do your activities of daily living and you don't have a plan for how you're going to bridge that sudden need, I don't feel comfortable leaving you here.
We got you up now. Could you let's go get some water together.
Yeah.
Or like something like that to kind of help you assess there.
What's the tipping point between a high-risk refusal and getting like an ECO?
We're going to talk about that. That's an outstanding question. So when we talk about high risk, we're really talking about, can this person make a decision for themselves? Am I comfortable with the decision that they're making? Going back to the autonomy piece, people are allowed to make decisions that we don't agree with. That is their right. But we need to make sure that they are actually making that decision and we're able to make that decision rather than the omission of a decision. The drunk that you find on the side of the road that you prop up and you're like, I think you're good, see ya. That doesn't count. They didn't make a decision. They weren't able to process, synthesize, and then communicate that information back to you.
And it can be hard because there's two separate issues that you pointed out. I just want to let Sean know. There's the consequences of their decision, and then do they have the capacity to make a decision? If they have the capacity to make a decision and it's a really bad decision, it's going to end horribly. They still have, I don't feel any more comfortable around that than you do. It's just greater comfort around the fact that they have the capacity to make it.
I called Dr. Weir on a Saturday morning one time after, he goes, this sounds like something an EMS captain should be on. I said, they've been here and left. I still don't feel right about it. And it got to the point, talking with him, he's like, some people don't make good decisions.
Yeah.
And like,
it is your right to make decisions that we don't agree with, provided that they're not harming somebody else and that you're actually making that decision. The one that stands out to me is guy with a new head bleed from falling and hitting his head against his toilet. Alcoholic, wants to die. However, he is not actively trying to kill himself. He does not fall into the criteria of a harm to himself or others. And after hours on scene, okay, this is a really shitty situation, but you have said goodbye to your family. You have said, I do not wish to go to the hospital. All of these things all loop together. And then the next day, we get the call for the cardiac arrest. You want to talk about the longest EPCR that I have ever written in my life. But ultimately, people are allowed to make decisions. It is not my values. And this is where that traditional ethics course in college is very helpful, where you don't have to agree with the person. They have to make that decision. So the things that we really get into with the high-risk refusals, we're truly talking about evaluating whether that person has the ability to make a decision for themselves. So we have the mnemonic curves from the EMS manual. Unless any of you are studying for the E-Tech test, I don't expect anybody to remember it because it's written down somewhere. But curves is, do they have the ability to communicate? Do they have the ability to understand? Do they have the ability to reason and apply that reason to their own set values? The other complicating factors that are involved in this are, is there an emergent condition? Again, do we think that there's a problem that needs to be addressed? And specifically, do we think there's a problem that needs to be addressed that is impacting their ability to make a decision? If I've got somebody who can't communicate effectively because they're having a massive stroke, well, that then moves us over in the direction of an implied consent if they truly can't communicate. And is there a surrogate there to make a decision for them? Is there a family member? Is there an identified power of attorney? Is there someone who is able to step in and assist us with making the decision to go to the hospital?
The EMS or the escape clause, then it no longer applies to the capacity because you have a different path.
So we have a couple of different things. It's in the front of the EMS manual that the EMS supervisors probably are very familiar with. But we have the delirium triage screening, which basically assists us with figuring out, is somebody experiencing delirium? Do they clearly fall into a concern that they're not making or having the capacity to make medical decisions for themselves? So the first component of that is, do they have an altered level of consciousness according to the Richmond Agitation and Sedation Scale? And really all that that's saying is this person sitting here and able to process information? We're not sedating them. We're not dealing with somebody that I am the reason why their RAS score is off, but it's more saying like, hey, is it like you guys? Can I sit down and have a conversation with you and you actually process it? How well can you figure out the capacity for decision making for someone who is actively punching their way through a fence? Do you think that they're able to hear Nate Giddings say, all right, now I see that you have a traumatic injury to your right inside of your wrist. It appears that you're bleeding, and I think that you likely would benefit from an assessment, potentially some stitches, and maybe a tetanus shot up at the hospital. Is that person who is actively punching through a fence able to understand any of that? No. So the first question on that DTS is the person able to participate in this conversation? Then, evaluating quickly their level of inattention. So in the list of other things that we ask folks to figure out, their ability to process information, their alert and orientedness, have them do something simple like spell lunch forward and backward so that you can see, hey, can you actually pay attention long enough? How many times have you had a patient that you're having a conversation with and you ask them a question, they start to answer it and then all of a sudden it trails off and either they just aren't talking or maybe they just aren't talking about something that makes any sense anymore. They may be able to lock in their attention for a brief period of time, but then it trails off. So if they fail either of these things, then we should move on to our next assessment tool, which is the confusion assessment model, or the brief confusion assessment model, which is broken up into a bunch of different sections: altered mental status, inattention, altered level of consciousness, and then disorganization of thinking. Can you reason normal things? Will a stone float or sink in water? Are there fish in the sea? Does 1 pound weigh more than 2 pounds? Not things that are word riddles, like you're not trying to be like, what weighs more, a pound of feathers or a pound of stones? It's very basic things. Hey, are you making reasonable sense?
If you've already done the DTS, you've done part of the DPM already. Because you've already answered the Richmond Agitation Scale. And you've already done like days of the week or lunch forward and backwards, you're doing the other one. So it's basically the same task again. So you really can simplify remembering it and you can just look at it.
Yeah. And surprisingly, and Easton's not here to gripe, this isn't in Hand Heavy, so we'll get this added to Hand Heavy so that it's in there as an assisting tool. The other piece that is on a lot of the buggies and probably should be put into Hand Heavy as its own standalone checklist is our form, the FRD 218, the Aid to Capacity Evaluation Worksheet, which this basically walks you through that BCAM process of answering these questions of, okay, are they able to understand the medical problem? Are they able to understand the proposed treatment? Are they able to understand some alternatives of that treatment? So I'm always on board with, hey, you won't go with me by ambulance, will you go with somebody else? You won't go with somebody else, will you go to your doctor? If you won't go to your doctor, will you go somewhere else? Like, let's come up with a plan here. If you won't go anywhere, we have somebody stay with you. What options do we have to potentially build a safer landing strip for you? Able to understand the option of refusing proposed treatment, including the consequences associated with that. Are they able to appreciate reasonably foreseeable consequences of accepting proposed treatment? I had a patient in Orange that called 3 times in the span of about 6 hours for new onset seizures. It was in the setting of, he has cancer. We're thinking, okay, this is probably something that's progressing with your cancer. I'm very concerned. He does not wish to go to the hospital. He's not in an indolite state with his other cancer treatment or therapy, so we're thinking he still wants to go through with this stuff. In order to fully make sure that he understood the potential foreseeable consequences, we had him and his mother have an end-of-life conversation. He said goodbye to his mom because he was unwilling to go to the hospital. Again, he understood the situation. He understood what was going on. It was a very difficult and complex case because we kept getting called out there because mom doesn't know what to do when he's having seizures. But he's still making decisions for himself. These calls are not easy, and these calls are not light on your own psyche. But we need to make sure that we can take out that mental component for ourselves, that behavioral component ourselves, and appropriately assess and document. Are they able to appreciate the consequences of refusing, including, I think that's basically the same thing restated again. The next piece with this particular form is, what does the impact of their depression have on their decision making? So, is the person's decision affected by depression? Does the person's decision affected by psychosis or delusion? So when we answer yes to those things, that makes us realize, okay, there's an outside factor that maybe that thing is the thing that needs to be treated. Maybe we need to ensure that they're getting back onto their depression medications. Maybe we're getting them back onto whatever mental health, behavioral health medications that they're supposed to be taking so that they can make these decisions appropriately. These get really confusing and concerning, specifically for the law enforcement partners that we run these with, because, and we'll talk more about how they go about their ECO, they are driven by, are they an immediate threat to themselves or others? Not necessarily the fact that the threat to them is the fact that they're so depressed they're not eating and they're not taking their medications anymore. So it kind of sometimes depends on which law enforcement officer that's standing there as to how they want to play that particular card. If you wind up having a person who screens positive on this, there is the very real possibility that this patient might be a candidate for a medical emergency custody order. And we're going to talk specifically about how we get to that point. And this is where I mentioned earlier that the legal component of this is a little mired and confusing, but we need to talk through it. So this is the first statute related to emergency custody orders that goes on in the Commonwealth of Virginia. And there are multiple different parts of this law. So this is the generic one. Any magistrate shall issue upon the petition of any responsible person. So what do we mean by responsible person?
It could be a loved one, it could be it could be an officer.
So they're specifically talking about someone who cohabitates with this person or who has responsibility with them. Somebody, a family member, somebody who lives there. A responsible person, they have to be able to make decisions for themselves. You can't have one drunk go petition for another drunk. But someone who, mom, dad, wife, somebody that would potentially be a decision maker if this person wasn't making decisions for themselves. Sworn petition of a treating physician. That gets pretty easy because if they're in an emergency department, if they're in a hospital setting, the treating physician has already been established. Or upon their own motion, so if the magistrate sees the person, they brought them there. If they have probable cause to believe that any person has a mental illness and there exists a substantial likelihood that as a result of the mental illness, the person will, in the near future, and what does near future mean in legal terms? It's completely ambiguous. It's based off of some, is it the next 4 hours? Is it the next 12 hours? Is it the next day? They have their guidance. The magistrates will make that decision of what is in the immediate future.
I have found it effective to give my interpretation of that to the magistrate when I speak to them. What I say is I anticipate complications threatening life or bodily function within the next 48 to 72 hours. That way it gives me latitude, because if you're not drinking anything for 3 days, it's probably going to have an effect.
Could cause serious physical harm to himself or others as evidenced by recent behavior, causing, attempting, or threatening harm, and other relevant information. So we get called for somebody who they told their mom, I'm going to kill myself. Okay, so there is a statement of an intent. There is the potential that this person is going to actually follow through with that. We don't necessarily have to be the ones that saw that interaction occur. That goes under the other relevant information category of, okay, I think that this person is a potential threat to themselves. You don't actually have to grill them until they break and say, okay, yeah, I said it and I meant it. You can't handle the truth. or if they would potentially suffer serious harm due to his lack of capacity to protect himself from harm or provide for his basic human needs. Somebody who is not able to care for themselves at all. They're not able to eat, they're not able to drink, they're not able to toilet, they're not able to take care of themselves, and we don't have a clear plan for how we're able to make that happen. Is in need of hospitalization or treatment, and is unwilling to volunteer or is incapable of volunteering for hospitalization or treatment. So one of the things that the cops learn is if the person voluntarily goes, okay, I don't need to do an ECO. If they say, yeah, I'll go to the hospital, cool. All right, I'm going to the hospital. I love that. If they're incapable of volunteering for hospitalization, we deal with this almost every single day. What does that fall under for us? What type of consent? Implied, because they can't. If they are unresponsive, they can't consent to that treatment. So that's where, again, we don't require an emergency custody order for everybody who's unconscious, for everyone who's experiencing a stroke or who's hypoglycemic.
So is that why the police always tell people, hey, you go to the hospital or jail to get them to volunteer?
So the hospital versus jail conversation is a different one. They're trying to make sure that they don't have to be the person who continues this, because they end all of their reports if it goes by us without their involvement. Okay, it's been turned over to Fireside. And they then don't have as much paperwork. They don't have to continue with their side of things. And usually that's in the setting of like drunk in public or something. Like the option is you either go get treatment or we're going to pursue law enforcement. And that honestly has gone down substantially since when I first got into the gig. Charlottesville police was famous for red or blue. If you pick the red lights, you go with the ambulance. You pick the blue lights, you come with me. That doesn't apply as much here. Because also bear in mind that emergency custody orders don't necessarily mean ambulance transport. That could mean that they're going to go by way of law enforcement to the hospital. It could mean that they're going by way of a private transport company with a law enforcement officer assisting with that transport. There's a lot of different directions that this could potentially go. But it always is preferable. Don't take away people's basic human rights to make decisions for themselves. If I can convince you, hey, Adam, you really need to get help, man. You're like, you know what? All right, fine, I'll go. That is far superior than me mandating that you shall. And emergency custody orders don't carry a lot of long-term consequences with them, but temporary detention orders do. And that is the longer downstream thing that we're not going to talk about in this setting, but TDOs impact people's ability to own firearms, impact other things besides just simply what's going on today.
Imagine it also impacts the therapeutic experience as well. Right?
Yeah.
So if you retain autonomy, then you're somewhat engaged and committed to your recovery, whereas if you're forced to, it kind of puts you in a moving adversarial position.
Yeah. Sometimes it is the leverage that we use of, hey, we're going to get you to the hospital no matter what, that suddenly they say, okay, fine, I'll go, voluntarily. So,
and that was for mental conditions.
That is the mental pathway. And we're gonna put the pathways up here in just a second because there's different ones. So for a law enforcement officer who, based on his own observations or the reliable reports of others, if they have probable cause to believe that a person meets the criteria for an ECO, so if they, having received their training through their initial law enforcement certification academy, as well as through CIT programs or whatever other things that they've talked about, if they think, based off of this evidence, that a magistrate would issue an ECO, they are able to take a person into custody and transport that person to an appropriate location to assess the need for hospitalization without prior authorization. That is what is known as a paperless ECO. So when Fairfax County Police shows up to a scene and they say, we're going to ECO this patient, it is almost always, if the officer says, I'm going to ECO this patient, it's almost always a paperless ECO. It falls under the behavioral health side of things. It requires that they believe the person is a threat to themselves or to others, and they are allowed to put that person into their custody to allow for an evaluation that happens immediately. So they're either going by ambulance or they're going by cop car to the hospital or to MCRC or another appropriate behavioral health facility. And it cannot exceed 8 hours for the initial assessment component. It then has to be continued forward with a paper copy. That's why most commonly when you or I interact with an emergency custody order, it's almost always under the paperless law enforcement pathway. It's somebody who said, I want to kill myself. Okay, we got to get you help. That's the end of this conversation. Makes sense.
And that timer is why you often hear them say, hey, start me the ECO timer
And it's a big deal. They shall do that. And the timer initially starts from, if it's a paper copy, the timer starts when the magistrate issues the ECO. Versus this is, when I say, hey, you're coming to the hospital, they start that ECO timer. The police officer has 8 hours, and they either have to release that person or receive an update from the magistrate of, yes, we're going to continue this. There are some components of like time of day and ability to get to a magistrate that factors into that. And we're not going to get crazy into the weeds, but this all comes, does everybody remember Krieg Deeds' son? Senator Krieg Deeds had a son who had significant behavioral health history. There didn't used to be the 8-hour rule. I think there was a 4-hour rule at the time of that legislation being changed. But essentially he was in a hospital, the timer elapsed, his ECO expired, he said, I'm going home. So they went home, and then unfortunately Krieg Deeds' son attacked his dad and then killed himself. So obviously somebody in a position of very large political influence and notoriety, something like this happens, that helped to leverage the change to the Virginia law.
John, did you at least place like a future coming attraction around inability to meet their feeding, water, and physiologic needs due to mental health conditions?
Yes, and we kind of looped that in under unable to provide for their basic human needs. So, and that piece comes underneath of that mental pathway. But we can
do a mental health condition, and then coming attraction will talk more about maybe in a small group or something. What constitutes a mental health condition? Is it singularly solely psychiatric illness, or do other neurologic conditions that may impair your ability to meet these physiologic needs fall under mental health? Because that can sometimes create a pathway.
Yeah. So the other medical pathway, so the first two that we've talked about was a paper psychiatric and a paperless psychiatric. The medical pathway for emergency custody order, any adult person who is incapable of an informed decision as a result of a physical illness or injury based on the opinion of a licensed physician, so not PA, not nurse practitioner, that an adult person is incapable of making an informed decision as a result of that physical illness or injury. Medical standard of care indicates that testing, observation, and treatment are necessary to prevent imminent and irreversible harm. Again, adult person can be taken into custody and transported to a hospital emergency room for testing, observation, or treatment. Now, the magistrate is also going to make sure that there is not somebody there who's not authorized to make this decision for them. So medical power of attorney, someone who would be a surrogate decision maker for them. And they also want to make sure that they're actually incapable of making that informed decision, and that the physician has actually communicated with that person that they're refusing transport to receive that necessary treatment, and they have indicated an intention to resist such transport. So Karen, when I said that there's different flavors of consent, like if you ask my mom, hey, Della, do you want to go to the hospital? She's like, I really don't want to go to the hospital. Della, you really need to go to the hospital. I don't want to go to the hospital. Della, come on, let's go to the hospital. All right, I'll go to the hospital. She's going to go. She's not going to fight you. There's different levels of this. But if they have indicated that there is an intent to resist that transport, do not get into a punching match with grandma. Check the brakes, let's take a moment. And it's unlikely that they're going to become capable of making an informed decision. So this is where that guy that I told you about with the seizures became complicated, because he kept, after his postictal period, coming back into a period where he was able to make decisions for himself. And they're decisions I didn't agree with, but he became capable of making his own decisions each time. The other caveat to this is that physicians can petition on behalf of a paramedic that is on the scene, and it says emergency medical services personnel, which means EMT through paramedic. The licensed physician has communicated electronically or personally with the personnel on the scene and has attempted to communicate electronically or personally with the adult person for whom this ECO is being issued. They've also personally attempted, meaning the physician has tried to obtain consent from the individual and they are unwilling to do so. Anybody want to be a lawyer now? It's a lot of complicated legal speak.
You're a magistrate, because that's a layperson.
Yes. They are not somebody carrying a JD. They did not go to law school. In the setting of a medical emergency custody order that is issued, that is always a paper copy, meaning that the magistrate has to issue it, and then a law enforcement officer has to get it in order to issue that summons. And it shall not extend beyond the period of 4 hours. So unlike the 8 hours where we have the concern that their person is actually going to be a threat to themselves or to others, so we want to keep them for potentially a little bit longer, you've got a timer going to get this person to an emergency department to provide whatever care that they actually need. So, I mentioned that there's different pathways for this, and we just talked about them. I find it easier to look at things through a graphic portion. So, medical ECO path, again, it has to involve a magistrate making a decision and actually issuing a summons for that individual. The physician has to communicate with EMS providers on the scene. So you actually have to pick up the phone and talk to a doctor. Nobody in this room, with the exception of Dr. Weir, has the ability to petition the magistrate for this. Now, if you at home have a family member that you would petition for a psychiatric, you do have the ability because you are a responsible person. But in this setting where your relationship with this person comes by virtue of the fact of the patch that you're wearing on your shoulder, you need to involve a physician. And it needs to be issued by the magistrate and actually brought physically to the scene. They do have workarounds for that. You will hear on Police Channel every once in a while, they're like, yeah, confirmed papers with the magistrate, and they'll issue the ECO based off of that. I don't know the legal aspects of that side of things. They can do what they need to. Dr. Weir, tell me if I'm wrong in my thinking about this. You guys generally, you and Dr. Dan, have a better knowledge of our background, knowledge, skills, abilities as an individual. My preference is to reach out to one of you two directly if it is reasonable and achievable to do so, to talk through this. And the part of the reason for that is what happened 28 days ago.
New laws.
What's that?
New laws went into effect.
New laws went into effect. Yeah, that's not what specifically I'm referring to. At all academic health institutions, the new group of physicians kicked into there. And I'm not saying anything negative, it's just a reality. And again, it's not as impactful here because I don't know whether junior residents are actually the ones answering the phone, but I did have to explain to someone what a paramedic was when I was calling for orders at another hospital. So the variability of what people understand about paramedics, about what we're doing pre-hospitally, it's wide. I'd rather speak with an EMS physician who understands, hey, why are you on the phone with me right now? Of course I want them to go to the hospital.
If they don't want to be cooking your dinner, you probably don't want them cooking your dinner. And when you're trying to get them to answer your need, they don't understand and they are incentivized to be less engaged. So we are available to you in that domain. It'd be cool if they owned it, since they're going to be getting it on the next leg of the race. But we recognize that's not the reality.
Yeah.
I also find you to have an understanding of kind of, like if I'm not conveying the information that you need appropriately, you're asking the probing questions to get me there. Whether that's affirmative or a negative, either one of them, they're asking the appropriate questions that they want to know in order to move forward.
Yeah. And
giving also reasonable alternatives. Like, I had one guy in the middle of the road that kind of wanted to jump into traffic on 495, and he's like, I would agree if the officer agrees that they are going to TDO them, I would agree to sedation. You know what I mean? Because now we are taking custody against their will, and so I will give you permission to treat against their will.
Yeah.
Kind of thing.
There's a knowledge gap, because I will say Virginia College of Emergency Physicians had a whole education campaign for emergency physicians about, yes, ECOs are your responsibility and you are expected to do that. But I don't think that seed has grown into a vine yet, because they still don't.
No.
Yeah. So anyway, the answer is yes, we're available.
Yes.
I did that Friday evening, actually. I went to the scene with EMS 4 and ambulance 434 to keep going.
Yeah. We're actually going to talk about that to the level that you're willing to. So the other pathway is the psychiatric ECO. We almost entirely live in this paperless world. Now, every once in a while, we'll get looped in for the paper option. And actually, recently, we were on scene of a patient who I felt probably would need to be ECO, but not for the medical pathway. And so we educated the family that was there of like, hey, here are your options. And I'm bringing you a police officer so they can weigh in on the magistrate side of this because I don't know where it is or who they are. But let me have this cop and me try to explain to you what your options are. And about 4 hours later, we get a phone call. Hey, we need you to come back to assist with an ECO. Okay, we achieved our goal of getting this person to the hospital, but it required that reasonable, responsible party to go and petition for this. So knowing the full breadth of all of the options that are available to get that patient where they need to go to.
That's a big one, that responsible party would petition the magistrate, right? Like, hey, we're not going to kidnap this person. The police are not at a point where they can do a paperless ECO. Hey, you family member, here are the options that you have to go to the magistrate and plead the case to have this person ECO.
Yeah.
You could build the rationale and make it make sense to them is that you've observed the behavior. You're telling the story firsthand, you live with them, you've observed it. Me telling it is one step removed, and in fact, the CSP or magistrate won't find that compelling because it's not firsthand evidence.
Yeah.
How do you get in contact with the magistrate?
So they can report. Yeah, you.
Sorry, go ahead.
So there's a phone number for you to be able to call, which involves this phone tree that kind of cycles over and over. You can also encourage folks to go there in person. So like the responsible party, like, hey, here's where you go to. You actually.
Where's there?
It's at the courthouse.
Yeah.
And there's also one in the south, but it's not 24 hours. One in the area, but there's one at
The South Government Center or something like that. I get the cops on scene because they interact with magistrate far more often than we do. They're the ones, the magistrate issues summons for obviously a lot of different things besides just this. So I would always rather, if I'm talking about a law thing, I'm like, hey, let me bring you somebody with a gun and a badge who got paid a whole bunch of money to go to school for this.
It's on the county website with directions, and the one at the courthouse is 24 hours a day. I think the one in Mount Vernon has like closing hours.
Yeah. Which doesn't make sense because that's part of the county probably needs it all the time. The other piece of bringing the law enforcement partner to the scene is it makes sure that we have truly exhausted, like, hey, are you sure you wouldn't want to just do a paperless ECO for this patient? Now, John, you brought up a good point earlier of if the cop doesn't, it hasn't risen to the level of the police officer performing a paperless ECO. Who ultimately makes the decision for the cop as to whether they're going to do this or not? Let me phrase this question in a different way. How many times have you been called to the scene by a law enforcement officer to do something, and then you do an assessment and you realize that from a medical perspective, that thing that they called you for is not actually what you're going to do?
Yeah, a lot.
So it's not uncommon for us to get called by our law enforcement partners, and Dr. Weir is working with our law enforcement partners to make sure that they realize they can call and ask us for something, but we would prefer that they didn't. Bring us to the scene so that we can do an assessment and make our own decision. So if somebody says, hey, I need you to come out here and ketamine this patient, I'm going to assess and decide whether I'm going to do that. And through my own set of training, my own set of perspective and values, I'm going to make that decision. The same is true if I call for a law enforcement officer and say, I think that this patient may be a candidate for an ECO. That's now their decision. I don't carry a gun and a badge. They are the one that has to actually come to that decision. Now I will obviously give them all the information that I have, why I think that they may be a danger to themselves or others, why I think that there may be a psychiatric condition at play that they need to intervene with. But they ultimately are going to have to make that decision. So it needs to be a collegial relationship where we actually work with our law enforcement partners and respect when they are limited by what they can and cannot do. Does that make sense? All right. Best practices related to those high-risk refusals and emergency custody orders. So the first thing, take your time. If you are in a rush to get through these, the only thing that's going to happen is you're going to get frustrated. Up to the point of sometimes taking breaks. Like, hey, I need to step away. I'm going to have Nate step in. Nate's going to continue to talk with you. We're here. We're not going anywhere, but I'm getting frustrated. And the more that I get frustrated, the less that I can communicate effectively, the less that I can reason, and the more likely that I'm going to do something that is going to cost me my job. Don't put yourself in that position. Take your time and be patient. Use leverage appropriately to gain consent. Now, what do I mean by that? What is appropriate use of leverage?
Not pushing it too far that you're having the opposite reaction.
Yeah, like you could turn somebody off.
Yeah, exactly.
Like, how dare you use that against me?
your daughter would be really upset if you
Yeah.
severe medical emergency.
Yeah. Get the appropriate people involved so that you can be like, hey, your mom really, really wants you to go up to the hospital. Have your mom be the one that says you really need to go to the hospital. Use those other points of leverage to make sure, empathize with them, develop that relationship with them, try to win them over rather than just simply, I'm here from the government and I'm here to help. Different providers sometimes can have different rapport. So Kim Hood, if you guys remember her, was the patient refusal whisperer. We could have been on scene for hours and then here comes the angry redhead that normally would cuss us out. And she goes, come on, sweetheart, and they just go. Like, I don't know where they went, but they went somewhere and to the hospital they disappeared. There are people who just, they have that ability. Miranda is another one who is just phenomenal. And I'll be honest, a lot of it comes from, I'm large white dude. I only see large white dude perspective. So when they bring in somebody else that looks different and is maybe a softer, kinder, gentler, sometimes that works really well. When in doubt, phone a friend. And that may mean that you're calling an EMS supervisor that's on duty. It may mean that you're calling somebody else. It may mean that you're calling one of the physicians to get them involved. Run it by somebody else. If you're like, I really don't feel good about this, let me involve somebody else. And there's a lot of providers who, through internship, they've been told, hey, involve your EMS supervisors in these high-risk refusals. Part of the reason that they do that by putting you on the call over the radio is that they want it time-stamped that a supervisor was involved in this discussion, involved in this decision. And it does build that evidence of clearly people on scene cared enough that they elevated this call. I would much rather that, and maybe frustrated at 2 o'clock in the morning being like, why am I here? Than for somebody to spend 15 minutes on scene and say, okay, well, this didn't work, and then we go run their code a couple of hours later, especially when it was poorly documented and we didn't do a full and complete assessment. Which leads us into the next part, document, document, document. We hit it all the time, but we own the most level of medical liability when we are the final point of medical contact. When we don't pass this on to somebody else, we own a substantial amount of risk. So make sure that you document extremely thoroughly what all you did, what you found, what was said, so that in 2 years, 3 years, 7 years, when you're asked about this, you have something to fall back to. Ensure clear communication with our partner agencies, with other stakeholders, and with the patient. Make sure that there's no question as to what was done to try to make this happen. And again, that's heading off the path of the complaints later on, especially if that person who is an appropriate stakeholder who has a right to that information is the one who called us. Make sure that they're looped in. Like, hey, here is, I spend as much time talking with the 911 caller when they're on scene. Somebody called for mom. Mom is refusing. I spent an hour talking with mom. I'll spend another hour talking with the person who called so that they fully understand what just happened. Why am I limited in my ability to assist or to take this person somewhere? What are your other options? What all have we tried? And I want to make sure if there's questions, let's answer them now. Use your resources. The FRD 218, we will get added to HandTevi as a checklist, the BCAM, all those things, making sure that they actually get added to the things that will assist you in the field. And then ultimately, just like anything else, make the right decisions for the right reasons. Have the patient's well-being in mind. If you are trying to do the right thing as a reasonable person, I won't say you'll never wind up in the wrong spot, but you're going to be in a much more legally and ethically defensible place if you're trying to do the right thing.